Thank you.
Hearing in the appeals, Pitman and Hernandez against the state.
Yes, Mr. Fitzgerald.
My lady, my lords, I appear for the appellants in these matters, my learned friend Mr. Paul Bowen of Queen's Counsel, Alison MacDonald, Ruth Brander, Amanda Clift Matthews, Daniela Wadoop, and Catherine Buckle. And the respondent is represented by my learned friend Mr. Peter Knox of Queen's Counsel and Tom Poole. My lady, I understand that the board is content that we deal with both issues together, as it were. That's to say that I first of all open the case in relation to conviction, and then deal with the question of sentence in relation to both Hernandez and Pitman, and that then my learned friend replies tomorrow in relation to both matters. Is that?
I'm not aware of ever being asked that question, but I don't.
Well, I was informed that that was what my my own friend thought that it was best to do it that way. If it's entirely a matter of
I'm
ladyship.
fairly sure that we will be content whichever way round you wish to do it.
Right.
We had understood that Mr. Bowen was going to be in difficulties getting here
Yes.
in time for this morning's hearing.
He's here present.
I'm pleased to see that he's managed to.
Yes. Okay. Then if I can just, first of all, check in relation to the conviction appeal of Mr. Pitman, your ladyship, my lords, should have a case and a reply to the respondent's case, and that has an annex to it, because some of the record had been left out. So it's the case and then the reply to the respondent's case, and obviously the respondent's case. And then in addition, there is an affirmation from my instructing solicitor Saul Lehrfreund, which is, deals with the affidavit that was mistakenly put in the bundle at pages 214 to 216 from trial counsel. And then there is the record, the supplementary record, and the annex to the reply. So those are really the materials in relation to the conviction of it. So if the board is agreeable, could I just take you to the submissions in reply, which really summarises the points that we are pursuing and sets out the reasons why we're pursuing. So
I'm ashamed to say that I've failed to bring mine. Has anybody got a spare?
It's page. Oh, yes. I'm sure we have spare copies. Submissions in. Yes.
Thank you very much.
That's now that document.
Yes. There's an annex to it.
Yes, I see.
Yes.
Don't worry, it's not your fault, but you probably ought to know that some of us only saw most of the late materials on screen.
I see.
And some of us don't read things if they're only on screen.
Oh, well, we did
In
provide hard
advance.
copies, but I'm very sorry.
Others don't read
I
them unless they're on screen.
Well, could I just check that have any members of the board not got the reply and the annex to the submissions in reply?
I have them now, and actually I had them before, but I just failed to bring them.
I'm advised, my lord. Well,
So where will...
Yeah.
What are we looking at?
yes, it's the submissions in reply at page electronic bundle page 758, and there should be behind that an annex which concludes. Yes, my lady, that's the doc. It's just because the voir dire proceedings, the
Yes.
only document that was available was provided was the voir dire evidence of Mr. Pitman, and just for completeness, we thought it right that the board should have the whole.
But
Yes, it may not be necessary to refer to more than one or two passages in it, but just so that the board had everything.
So, to follow your argument today, we're going to need your submissions in reply,
Yes.
prosecution case, and your speaking note.
Yes, my lord, that's right.
Right.
Submissions in reply on the case on conviction.
what's this about a speaking note?
My lady, there is a speaking note that's available which summarises the case very shortly. It's on your ladyship's desk. Yes. That's on sentence only.
Oh, sentence.
Yes, that's on sentence only.
Right.
Yes, it simply summarises the points on.
Well, I'm not even sure that I've got something with a pink tag on my desk.
But we have many copies.
Thank you.
I'm sorry
I now do.
I'm obliged.
I'm sorry to prolong the inquiries about documents, Mr. Fitzgerald. It isn't your fault, but I personally hadn't seen the additional voir dire transcripts behind your
Yes.
submissions in reply. The submissions in reply came electronically on Friday afternoon. I've read those. I hadn't, as far as I know, seen this, but I've got them now. But what are they?
Basically, what the board had in the supplementary record was the voir dire evidence of Lester Pitman. The other witnesses who gave evidence in the voir dire, the board did not have.
That's
it
right.
may not be necessary to refer to more than one passage in it, but so that the board, in case you wanted to see it.
But it's all trial material.
It's all trial material.
From the voir dire.
Exactly.
Thank you.
That's all it is, yes.
Got it.
And the only passage I may need to refer to it in it is the aunt's evidence.
Let's just recap. On the conviction appeal, we should have your written case,
Yes.
which includes the Ruddock point as well as everything else. Yes?
Yes, absolutely.
We should have the respondent's case, which also replies to the Ruddock point.
Yes.
And we should have your reply submissions with the additional item from the record.
Yes, my lady, that's
That's what we need on conviction.
That's all you need on.
Yeah, well, we'll sum up what we need on sentence when we get to it.
Yes, absolutely. My lady, in that case,
Make sure that we have ourselves in the right position.
Yes, right. So, if I can then take the board to the submissions in reply on conviction at page 758.
Yeah.
So this really is just summarising the points that we pursue and do not pursue. Yeah. Firstly, as to unfitness to proceed, to plead, we do not pursue the issue of unfitness to plead, and that is because it is accepted that the evidence that was adduced in the Court of Appeal is insufficiently conclusive for the board to be able to reach a conclusion contrary to that of the Court of Appeal. So that's the position on unfitness to plead. In relation to the admissibility of the confession, which is the second point, we do pursue the submission that the confession should have been ruled inadmissible. And just summarising it very shortly, that's because it was a finding of the board on the earlier occasion that at no stage during the time between the appellant's arrival at the homicide office and the conclusion of taking a statement was any accompanying person present with him, nor did he see a lawyer during that time. Those were the findings of fact made by the board in their earlier judgment of March 2008. But now it has been established before the Trinidad Court of Appeal by unanimous medical evidence that the appellant suffered from arrested or retarded development in the form of mental retardation. And then we say, given that, the absence of an accompanying adult or a lawyer assumes a new significance. It's at paragraph 69 E and paragraph 68 of the Court of Appeal's judgment that they record the finding that he did suffer from arrested or retarded development of mind. The board will be aware that there were 2 IQ assessments before the Court of Appeal, one of 54 and the other of 67, but both of them brought... 52. So one of 52 and the other of 67. I'm right, 52 and one of 67. The effect is that both of those assessments were below the 70 cut-off point, and both would have justified a finding of intellectual disability. And so this was someone who, on the Court of Appeal's own finding, suffered from an abnormality of mind arising from arrested or retarded development, and therefore taking the form of an intellectual disability. And we submit that in the light of the fact that there was an intellectual disability of that degree, and in the light of the fact that he was in the police station without an accompanying adult and without a lawyer, the confession should have been ruled inadmissible.
Inadmissible?
Yes, inadmissible, and is yes.
But not on the basis of involuntariness?
On the basis of unreliability. Yes.
Which is...
Simply unreliable.
Which is usually a matter for the jury, isn't it?
Well,
Anyway, you'll develop it.
Well, not under section 76.
I see. Excluded on that basis.
Yes, on basis.
Right.
Well, you do mean, actually, that it wasn't shown that it was voluntary, don't you?
Yes, but my lord.
You
yes.
have to say that.
Yes. It's yes, my lord.
But you're going to have to come to the question of whether an intellectual functioning below 70 by itself is sufficient to mean that the Crown has not shown that it was voluntary.
Well, yes, my lord. Essentially, the three matters we have there are an IQ below 70.
Yeah.
The absence of an appropriate adult, and the absence of a lawyer. If those matters of themselves do not render it a case where it can be said it can't be shown that it's voluntary or that it's unreliable, then that's the end of that point, if I can put it that way.
I'm sorry to quibble,
No.
but you say unreliable again. Yeah. What do you mean by that?
Well,
it's to be admitted unless it's isn't it? Unless there's doubt about its voluntariness.
yes, my lord.
Yes.
But my lord, we would also say that one can
inaccuracy isn't it anywhere?
No. Well, you can look back subsequently,
right,
at the appellate level, and say that given those three factors, the confession is unreliable.
Right.
You'll be developing this in your argument, but there are two quite separate strands here, aren't there? One is the question of admissibility, which depends at common law on the pure question of voluntariness.
Yes.
The second question is whether it ought to be excluded on the basis that it's either there's been a breach of judge's rules or that there has been that its prejudicial effect outweighs its probative value. That's a different limb and brings different considerations into play.
Yes,
and you'll make clear whether you are running both those arguments or one, and if so, which, when you come to develop it.
My lord, yes. Well, my lord, I think the answer is we are saying that something said or done to him renders it involuntary. What was said and done is he was questioned, being a mentally handicapped person, in the absence of a lawyer and in the absence of an appropriate adult. That's the voluntariness issue. And then we also say that it should have been excluded, and that this board, looking back, can say it should have been excluded because of the fact that he was someone with an IQ maximum of 67 who was suffering from the mental disability and was unaccompanied by either an appropriate adult or a lawyer. So that's the way we put it.
So you're riding both horses?
Yes, madam. There we are. If I could then briefly summarise the position on joint enterprise. On joint enterprise, the respondent has now conceded that the judge misdirected the jury on the issue of joint enterprise. That concession is made at paragraph 5 of the respondent's case. The respondent submits, however, that the point should not be reopened because there would be no substantial injustice if leave were refused to advance this point. And we submit, firstly, that on the issue of no substantial injustice, there are a number of issues. Firstly, it's not a case where the issue of joint enterprise is invoked post-Jogi and Ruddock to reopen a case on that sole ground. This matter was before the board. It was remitted for findings as to the impact of mental disability on issues including joint enterprise. So it is, as it were, an incomplete hearing. On this case...
Is that another way of saying you've already got a live appeal against conviction?
My lord, yes.
You don't need leave to pursue a new one out of time, and you don't get into that raft of cases in the Court of Appeal here.
Absolutely, my lord. That's exactly as your lordship well knows. At paragraph 100 of Jogi, the issue was very much formulated on the basis of the reopening of a case by leave to appeal many years out of time. And this isn't a case where someone is coming, having had their case disposed of many years ago and saying, could you reopen it on the basis of Jogi. It's a case where the matter is before the board, where one of the issues on which it was remitted back to the Court of Appeal was the impact of joint enterprise, the impact of the mental problems on joint enterprise, and therefore it's already properly before the board. The respondent, secondly, relies on the fact that there was an earlier hearing before the board, but the board on the last occasion expressed concern about the directions on joint enterprise. At that stage, they could not proceed on the basis of any proven case of mental disability. They were simply giving leave for the issue of mental disability to be explored in the light of the evidence that was admitted before them of Professor Kopelman and the psychologist. So this is a new factor which is now available to this board and which now justifies a re-evaluation of the judge's direction in the light of the law as it has now been clarified. So again, if there is concern, as obviously there was in the Jogi case on the part of both the board and the Supreme Court, as to whether the floodgates are going to open in every case where there's been a misdirection in the past will be reopened. There are special features of this case which distinguish it from all other cases. That's to say, the fact that it's already properly before the board. And secondly, that the board expressed concerns about the directions on joint enterprise, but when it was last before the board, as it were, the investigation was incomplete because the issue of mental incompetence had to be remitted to the Court of Appeal. The third point we make is that the context of the misdirection is significant. It went to the heart of the sole issue in the case in circumstances where the confession was the central evidence against the appellant. The board found that there would be no, on the earlier occasion, in the record found there would be no case without the confession. And that's at, I think it's paragraph 8, but the...
Well, the judge directed the jury in these terms.
Yes. So it is the sole issue, the issue of joint enterprise raised by that confession.
It wasn't that there wasn't any other evidence, but the judge directed the jury that it wouldn't be enough.
Yes.
Yeah.
My Lord, I'm right. The fourth point we make is that the misdirections on joint enterprise were serious and repeated. I won't, at this stage, go into them in detail, but just summarising, the judge repeatedly directed the jury that it was sufficient that it crossed the mind of the appellant, Pitman, when his co-accused went into the bathroom, that he might cause grievous bodily harm or kill. So the fact that it crossed his mind would be sufficient. So it's not just a direction of foresight, it's a direction of momentary foresight. It crossed his mind, being sufficient to render him having the mens rea.
Under the old rule, it had to be more than momentary foresight, did it, or what?
No. A momentary would have been sufficient, but it's
Any foresight would do.
Yes, but it is a significant fact in our respectful submission that it is just. It's not. Did he go out before seeing it? It's did he at that moment when his co-accused went into the bathroom, did it cross his mind? So that, as it were, puts the context. We say it's fundamentally different from a direction that there be joint conditional intent, which the board in Ruddock found would be enough, and which my learned friend Mr. Knox says, well, it's a thin dividing line between the foresight, which is not enough, and joint conditional intent, which is enough. We say it's fundamentally different from joint conditional intent.
Well, it isn't actually joint conditional intent.
No, it might be one person had the conditional intent and the
yes,
other person had the
Precisely.
actual intent.
You may have one very unconditional intent and the other conditional.
Yes. Sorry. Yes. Could I invite the board to strike the word joint from the record? It should be. I apologise. Your Lordship's absolutely, of course, it should be conditional. The participation by way of to use violence amounting to GBH if necessary in the enterprise. That's it. And we say it's fundamentally different. And the sixth point we make is impossible to say, as the respondent claims, that on the trial judge's direction the jury must have found conditional intent. And equally impossible to say it's highly probable that the jury would have convicted on a correct direction. And we say you can't ignore the fact that the judge repeatedly directed the jury it was sufficient that it crossed his mind that his co-accused might have gone back to the bathroom. And then finally, on this part, we say we don't accept that a conviction for manslaughter was inevitable. And that's because the assent to some harm is one thing, but what happened when the co-accused went into the bathroom and cut the throats of the victims was, we say, quite separate. And moreover, we say that the act to which he can be said to have assented, that's to say, some harm in the course of tying them up, is quite different from the act that took place at the later stage in the bathroom, which was an act, obviously, of complete violence, murderous violence. And he didn't assent to that some harm at that stage at all. So it's not a case of where you assent to some harm being done and then more is done. He had said, let's go. The co-accused had gone into the bathroom and we say he didn't consent to any harm at that stage.
Can I just ask, so I know that you'll get to it.
Yes.
That raises two questions which you're going to have to deal with. The first is whether there's any assent involved in manslaughter at all.
Yes.
At least assent to harm.
Yes.
Or whether it's enough that there is participation in a violent act which carries objective risk of harm. And secondly, there's the continuation of the joint plan point, if you like.
Yes.
Those are, I think, different points, aren't they?
Yes.
But you'll deal with them.
Yes, my Lord, I will. Well, I hope I will. I hope I'll deal with them satisfactorily. But I appreciate that those are points out. And then finally, just in summary, it's been suggested by my learned friend, well, it wouldn't make much difference whether you were convicted of manslaughter or murder because you'd get the same kind of sentence in any event. We say that has to be wrong, and wrong both as a matter of fact and wrong in principle, that a conviction of manslaughter on the basis of some harm being contemplated and the joint enterprise involving some harm is wholly different from conviction of murder. The sentence would typically be either a long fixed-term sentence, or if there was some mental element, possibly a discretionary life sentence. There would be no provision for the adding of a minimum term, because there is no provision in Trinidad, so far as we understand it, for the adding of a minimum term of 40 years if it's a discretionary life sentence. They don't have the same provisions.
And what if any part does felony murder have in all this?
Well, my Lord, we simply say that was never left to the judge. That wasn't an issue. The judge said, "I'm not going to leave felony murder." So to, as it were, speculate about what would have happened if the judge had left felony murder, we respectfully submit would be impermissible.
So you say we don't need to think about that at all?
No, that is our because the judge simply said, "I'm not going to leave felony murder."
Going back to your previous point, at some stage, will you tell us where the power to fix a minimum term attached to some kind of a life sentence is found? Not now, at some time.
Yes. Well, my Lord, yes. Certainly, it happens when there's a commutation.
Yes. Is it in fact what happens when there is a commutation?
Well, yes. When you commute the sentence from death sentence to life sentence, the executive can do what it likes. So they can say, as it were, we substitute life and say that you should do at least 40 years. But whether there's an equivalent of the special provisions in the Murder Abolition of Death Penalty Act in England and Wales, that's to say that you can, at the time you impose a life sentence for murder, declare the minimum term that should elapse. Yeah, your Lordship, looking puzzled.
It does go back to that.
Yes, that would be the only power. There's no tariff procedure such as we have now elaborated in England, in Trinidad.
So under what power did the Court of Appeal do it?
That is questionable. That's questionable. The only power is if there is an equivalent power to the section 1(2) of the. Sorry, it's 1(2) of the murder.
They must do that all the time, because these sentences are being commuted all the time. Because five years regularly goes by.
Yes, but the court doesn't do it because as a result of Hunter.
I understand the court doesn't do it, but we'd still be interested to know on what lawful basis the executive does it.
Well,
does it have a policy? Or does it just dream up some number when it comes, or what?
Yes, well, my lord, the
don't we know?
only justification for it is that they can say that since they're giving less than the death penalty,
So they can say 100 years, could
they could. In fact, in some cases, they say for the rest of your natural life.
Yes.
And there have been a number of cases where they've commuted and said, I'm not saying they can do it because there's an issue about whether they can, which is coming before the board shortly, but they have been saying life, meaning life for the rest of your natural life. They have been saying life with a minimum of 75 years. The issue of whether they can lawfully do that is one that is coming before the board. But the rationale for saying they could do it is that if you're giving something less than life, you can do...
Less than death.
Sorry, less than death. You can do whatever you like.
But whatever the answer is, that's a matter for the executive, not for the court.
Yes, yes. My lord, moreover, this would be a discretionary life sentence. It wouldn't be a conviction of murder case. And I've checked because we, fortunately, have a very distinguished Trinidadian lawyer present in court. And so far as he's aware, and so far as our researchers can show, when it's a discretionary life sentence, consequent on a conviction of murder, manslaughter, there is no power.
Well, if it's manslaughter, yes. Yeah. That's a discretionary life sentence. But if it is murder,
yes,
we'll have to wait and see whether we get there or
Yes.
not. But if it is murder,
yes,
the only sentence that's provided for in the legislation, as far as I can see, is death, isn't it?
Yes.
Everything else is done by way of commutation.
yes,
Got it.
yes, yes.
Yep.
Okay.
So it's not a discretionary life sentence.
No, but...
No, but Mr. Fitzgerald's remarks were in the context
Yes,
of the conviction
I
for
follow.
Yes, I'm looking. If you were to substitute...
Got that.
If you were to substitute manslaughter...
Yes.
My learned friend, Mr. Knox, says, well, it wouldn't make any difference. You'd still, on a manslaughter conviction, get life with a minimum of 40 years because there's 3 victims and it's a terrible case.
Yeah.
We say that that's wrong in principle. I mean, you simply couldn't say it makes no difference that you've been convicted of manslaughter rather than murder, and we will simply give you the same punishment. I mean, that as the most fundamental sentencing principles would be offended if you did say that. Our position on
So what was the Court of Appeal, when they commuted it, if they did commute it, first of all, did they have any business commuting it? And secondly, and on your case, they didn't have any business commuting it. Because the executive should have commuted it, not the court, is that right?
Well,
the
case of Hunt and Khan decides that they can't commute. Of course, since I was arguing that they can commute in an early case successfully, all I can tell you, Your Lordship, is that that this board has decided in Hunt and Khan that the Court of Appeal, exercising its powers, could not say on grounds of delay, we're going to substitute a life sentence.
But what it could do in its capacity as a hearing a constitutional petition, deal with it on that basis.
Yes. So if you brought
The difficulty was that this board couldn't.
Yes. If you brought a constitutional motion saying 5 years have elapsed, then in exercise of Section 14 powers under the Constitution, the Court of Appeal could do, well, the courts could do whatever they thought necessary to fashion an appropriate remedy.
But on a straightforward criminal appeal,
Criminal appeal,
Can't be done.
That's what Hunt and Carnes decides.
Yes.
Yeah. Yes, and we're not inviting the board to revisit it. But,
3 bites at the same cherry in a relatively short amount of time. Not a lot of people on your side, Mr. Fitzgerald.
The board also said that its decision did not affect the validity of commutations which had been made by the Court of Appeal, albeit, as we held second time around wrongly, for reasons which were explained, and the state also indicated that it would not, in any event, seek to reopen any of those past orders. So the validity of the commutation is not an issue in this appeal, as I said.
Yes, that's absolutely right. My known friend, Ms. Knotts, has indicated that there's no challenge to the commutation. Or the reduction of the sentence by the Court of Appeal.
Yeah.
Yes. We've summarised the position on diminished responsibility. It may just be important to explain the basis of the concession. We accept that on the evidence that was before the Court of Appeal in relation to diminished responsibility, there was insufficient evidence for this board at the, as it were, tertiary level to substitute a verdict of manslaughter on grounds of diminished responsibility. And that's because Professor Kopelman simply stated there was diminished responsibility. He did not explain how the abnormality of mind would have operated to diminish responsibility. And Dr. Maharaj equally said he didn't think it did substantially diminish responsibility. He didn't explain why, but in those circumstances, the Court of Appeal made the finding, which we've recorded at 1.5, page 761, that though there was an abnormality of mind arising from arrested or retarded development, they did not find that it had been shown on the balance of probabilities that it substantially reduced responsibility, substantially impaired responsibility. We would maintain that if the matter were properly canvassed, there would be a very powerful case that the intellectual disability would necessarily have had some impact, more than trivial impact, on responsibility. But that was not explored, and no evidence was adduced to establish that at the Court of Appeal. So we could not invite this board at this level to, as it were, second-guess the position or say, well, it is a natural inference that it did have an impact, such as to prove on the balance of probabilities that there was
But if you succeed on your sentence point,
yes,
what's going to happen next?
if we succeed on the sentence point, then we submit that the death sentence would be set aside and the matter would be remitted for an appropriate sentence to be substituted.
Remitted to who?
To the Court of Appeal.
Well, the death sentence has already been quashed,
Yeah.
so there's not much we can do about
No, sorry,
that.
sorry,
but
the-
it would have to be remitted for...
Yes,
yeah.
yes. So, well, the sentence of life with 40 years minimum was imposed on the basis that the death penalty had been properly imposed, and that this was an alternative to the death penalty which had been properly imposed. If the death penalty had not been properly imposed because of the issue of mental impairment, then what we would respectfully submit is the matter should be remitted for the Court of Appeal to deal with. And, of course, one of the arguments we...
So then all these points which you've now, if you like, conceded in this court will all come live again, will they?
They'll come back. Well, not the unfitness to plead, but the...
No, not the unfitness.
Nor diminished, presumably,
But all the...
because that would go to conviction.
Yes. My Lord, just as a matter of practical reality, this happens the whole time, if I can put it this way, that where the death penalty is discretionary, for instance, in the Ray's case, which was the test case, it was found by the jury that he didn't have diminished responsibility. The case was remitted back to the Court of Appeal, having found that the mandatory death penalty was discretionary. It was remitted back to the Chief Justice of Belize to determine an appropriate penalty, and he found that he effectively, I didn't use those words, effectively did suffer from diminished responsibility because he was dealing with a sentencing stage. Now, what we submit is, if the correct position at law on the sentencing stage is this, that you cannot be sentenced to death if you are suffering from intellectual disability that renders it cruel and unusual punishment, then the matter would be remitted to the courts below to re-sentence in the light of that principle, and it would be perfectly possible within the powers of modification under Section 5 of the Constitution Act to fashion a remedy, that's to say, to give an alternative sentencing power to the courts in cases where the common law prohibition, the common law exception applied.
But presumably then it would be relevant to consider whether or not the nature of the impairment, if you like, or disability, substantially reduced responsibility or not. Indeed, the very same issue as would arise, or something very, very close to it,
yes,
as would arise on a manslaughter.
Well, my Lord, can I answer
right.
to that? Yes, can I just put two
The
points?
whole situation is far from satisfactory.
No. Well, my Lord, can I just say that, again, where the death penalty is discretionary, it happens the whole time.
Yeah.
I can give you almost 10 cases off the top of my head where either diminished was not run, or diminished was run and rejected by the jury, but once the discretionary system came in, the court dealing with the question of what is the appropriate penalty recognised that there was a degree of diminution of responsibility by reason of mental disorder when at the sentencing phase they came to address that.
What you're saying, Mr. President, as I understand it, is that if you get back before a court which is having to consider sentence afresh, then whilst the partial defence of diminished responsibility will be long gone,
Yes.
A diminution of responsibility by way of mitigation will still be open to you.
My Lord, yes.
And whichever court it is will have to grapple with the problem of whether you can have yet more psychiatric reports prepared 10 years after the event or whether you can't.
Yes.
Okay.
My Lord, yes. That's subject to our first point, which is subject to... So,
But I suppose you'd not only be looking at it as at the petition, as at the time of the crime, as the mental state as at the time of the crime, but as at the time of the sentence.
yes, because some of the rationale for the prohibition is to do with, is this someone who's fit for execution? And that has to whether they are prepared for the ultimate ordeal, as in words of Guerre and Baptiste, and also whether it's contrary to human dignity or cruel for someone who is, who is intellectually disabled to be executed. My Lords, also, our primary submission on the sentencing appeal is that if you're under 70, that's the cut-off point. So it would only be if that was rejected and it was said you'd have to make out that you were under 70 and that rendered execution cruel and unusual. So if this board followed the approach of the US Supreme Court in Atkins, you'd simply say that if you are found to suffer from an intellectual disability that brings you below the cut-off point, then you simply can't be sentenced to death. And that's our first submission. So it's only in the alternative, if you rejected that, but still found that the issue of whether it's cruel and unusual to execute had to be looked into before sentence was passed, that then there would be the exercise of, well, yes, this person is below the 70 cut-off, but is that enough to render it cruel and unusual in this case? So that is the position. I should, well then, can I, because of the pressure on time, can I just try to very briefly deal with the confession point? And I recognise that there are two issues that I need to deal with. This is at part 2, page 762. The first issue is, does it render it involuntary? And the second issue is, would the facts be such that it should have been excluded in discretion, having regard to the three factors, the mental disability, the absence of an appropriate adult, and the absence of a lawyer?
Yes, I was looking to see how the board looked at a parallel question in Hunt and Khan, because in that case, the board accepted that it was incontrovertible that the police had wrongly prevented Hunt from the services of a lawyer, and that this was described by the board as being a serious breach of an important constitutional right.
Yeah.
That was paragraph 23 of the judgment. Yeah. And then at paragraph 24, it's authorities bundle 10, page 246. We said it didn't automatically follow the judge was wrong to admit the confession statement. That required the board to consider two questions. First is whether it was admissible as a matter of law, and that turned on voluntariness. Secondly, whether fairness required it to be excluded, because there was a serious breach of an important constitutional right. We have a parallel situation here, don't we?
Yeah, yes. I think that must be right. That so we would certainly submit that. Well, the only way we can put it in terms of voluntariness is if you ask yourself the question: was it admitted as a result of things said or done which render it involuntary? Then it would be the bare fact of being questioned by the police in the absence of a lawyer and an appropriate adult when you're suffering from intellectual disability renders it involuntary.
That you've got some point to grapple with the evidence of the magistrate.
Of Mortley.
The JP.
Yeah.
Yes.
Because it's not simply a question of him being questioned by the police. That he before the statement is given, there is the meeting between the appellant and the JP.
Yes.
And you've
Given
got
to the JP, isn't it?
Yes. Yes. The JP.
given to the JP.
JP says, have we got the JPs at the
Yes, you have.
trial?
Yes, you have. Sorry, at trial. No, we've got it in.
We've got it in your new batch of, yes.
You've got it in the voir dire, yes.
Because I raise this because you say the bare fact of being questioned by the police,
Yes.
absent an appropriate adult, equals involuntariness, or rather a failure to demonstrate voluntariness. The prosecution sought to demonstrate voluntariness by the evidence of JP.
Yes. Well, my lord, he'd already indicated a preparedness to make a confession before that. So really, that's the only point that we can make in response to that. And really, the second point that we make is that if one takes those the three factors, if I can just call them that, it would be unfair to admit the confession, having regard to his mental disability, having regard to the absence of an appropriate adult, and the absence of a lawyer. And really there we rely on the cases in the English jurisdiction that we've referred to at 2.5, where the absence of an appropriate adult has been regarded as sufficient to render it right to exclude the confession, and on Lord Bingham's statement in Ashley King that it is appropriate to look at later cases decided under a different legal framework when assessing the requirements of fairness in a particular case.
Mr. Fitzgerald, can you help about this? The role of an appropriate adult is not to act as a legal advisor. It's just to sit there and satisfy himself as to fair, or herself as to fair play, and intervene if there's cause for concern.
Yes, they can talk to the
Yes, certainly.
person, they can counsel.
They're not there in the role of being the defendant's
Yes.
attorney. They're there for the purpose just indicated. Now, what difference in reality is there between that and the role of the JP?
Well, I suppose the difference is that they're not the appropriate adult is not a representative of the state coming to, as it were, obtain the confession and to sign for the confession. The JP has we don't have obviously a parallel with that.
But he is there as an independent judicial officer, isn't he?
Yeah, yes, I accept that. Yes. Well, but he's not. But he doesn't have any, as it were, counselling or.
No, but nor does the appropriate adult have a counselling role.
Well, they have a supportive role, I suppose, is the answer.
Well,
Well, it's counselling as to different things from the law, isn't it? It's a counselling role, but it's counselling as to different things
Yes. So they're there to support the person, and obviously one of the things that they may well do is say, well, you really ought to get yourself a lawyer.
Maybe.
have you got in the bundle the documentation on as a matter of interest, on the English and Welsh appropriate adult scheme?
Oh yes. It's in the annex. It's in bundle 9. Bundle 9 at tab 1, and it's at pace code C, and it's annex E. So it's page in the electronic joint bundle of authorities. It's page 3666.
Bundle 9.
Yes, volume 9 of the authorities. So it's it's at tab 1 of volume 148. 148. It's the first one. It's the first one, but it's 148.
Code of practice.
So
Did you say 3666?
yes, 3,666 in the authorities bundle.
I'm afraid you may find, Mr. Fitzgerald, that the electronic version we've got of that particular bundle starts at 1 again.
Oh, right. Well, in that case, if it does, if you go to tab 148, it's Annex E of the Codes of Practice.
Yeah.
But those of us who would like to look at it electronically,
Yes,
how are we going to find
the
it?
internal numbering is at page 69 of tab 14.
That's no help.
Well, I think we can probably provide, if we've got a spare. My lady, if we've got tab one. Is that volume right? Just
Quite a long way down the line.
Oh, well, if we have one copy of volume 9.
Annex E is going to be at...
No, we've got the hard copy. It's
Oh.
just that my lord and I like to look, despite what I said earlier about not reading submissions unless they're in hard copy, I like to look at all the materials on screen, as indeed does my lord. And
73. 73 in the electronic version of the supplemental authorities bundle which reached us on Friday.
That's volume 9, yes.
And it's within tab 14. The tab numbers have come out the same as your hard copy, but the cumulative electronic page numbers, sadly, are not there on the electronic document.
Yes, I see that you're right about advisory capacity. The central paragraph is paragraph 9, which states what is the purpose of the appropriate adult's presence.
Yes, to advise the interviewer.
Advise the interviewer. observe whether the interview is being conducted properly and fairly, facilitate communication.
So that would include advising
Yeah.
you need a lawyer.
Yeah,
Do all members of the board now have...
no. I'm not sure. We've got 3 different documents. We've got the joint bundle of authorities in both cases. We've got the Pitman and the State document, and we've got the Hernandez and the State document.
Well, I'm just wondering...
And then the supplemental authorities bundle on top of that.
supplemental.
Came in on Friday.
Well, I haven't got that.
Yeah, I'm afraid they did rather trickle in on Friday.
I do... Would my lady, would this be appropriate? Since I'm going to be since I was going to refer to Aspinall and Ashley King,
Yeah.
could I simply move on to the joint enterprise, and if necessary, I mean, I think the board has the summary of how we put the case, and if necessary, come back to this.
I understand that, but this is an aspect of the case in which I'm particularly interested.
I gather we can fix this. My learned friend, Mr. Bowen, who is a technological expert.
No, it's all right. It's going to my lady's inbox as you speak, Mr. Fitzgerald.
Thank you so much.
Okay. Well, okay. In that case, I'll simply put that.
I think without being unduly harsh, this is not an exemplar of electronic filing in this case, Mr. Fitzgerald.
I mean, given the case has been listed for as long as it has,
I apologise.
I appreciate the difficulties under which you all have to labour in cases like this.
Well,
we do understand that.
I'm obliged, my lady. Of course, that's there were some additional materials which we felt.
So which actual document are we looking at now?
Volume 9,
Yeah.
tab 148,
Yeah.
and it's at Annex E, page 3666.
Thank you.
And my Lord Toulson had drawn attention to paragraph 9 over the page at 3667. If the appropriate adult is present at an interview, they shall be informed they are not expected to act simply as an observer. The purpose of their presence are to advise the interviewee, observe whether or not the interview is being conducted properly and fairly, and facilitate communication.
Now that's an annex to the Code of Practice established for England and Wales under the Police and Criminal Evidence Act, as variously amended from time to time since 1984, yes?
Yes.
Doesn't apply, of course, in Trinidad, but you say what it demonstrates is the kind of precaution which is necessary if you are interviewing somebody whose IQ is at this level.
My Lord, that's exactly it. And the judgment in the Ashley King case provides some assistance, because it said in Ashley King said you can have regard to rules that are subsequently introduced as an indication of what would be fair and what would promote a reliable confession, if I can put it that. And can I just show you it's a very short passage, but it was where there was a very old case, and leave was granted 12 and a half years after conviction, and it's at tab 149 in the electronic 3677. I don't know what you'll
Next tab.
It's the next tab.
Yeah, the next tab. And in that case, at page 402 in the internal pagination, at 402B, one has, in looking, this is Lord Bingham, in looking at the safety of the conviction, it is relevant to consider whether and to what extent a suspect may have been denied rights which he should have enjoyed under the rules in force at the time, and whether and to what extent he may have lacked protections which it was later thought right that he should enjoy. So both, you can look, as it were, at the position as it was at the time, and under the rules which it's later thought that he should enjoy. But this court is concerned only with the safety of the conviction. That is a question to be determined in the light of all the material before it, which will include the record of all the evidence in the case and not just an isolated part. If in a case where the only evidence against the defendant was his oral confession, which he later retracted, it appeared that such confession was obtained in breach of the rules prevailing at the time, and in circumstances which denied the defendant important safeguards later thought necessary to avoid risking a miscarriage of justice, there would at least be a prima facie grounds for doubting the safety of the conviction.
Sorry, that breach of the rules prevailing at the time in that case.
Yes, but it then goes on to, and in circumstances which denied the defendant important safeguards later thought necessary to avoid the risk. So it's both. You can look at, as it were, so in our case, you can look at, was there a breach of the judge's rules? Well, there wasn't. We have to accept that, although, and the judge's rules do not deal with this issue. However, it has later been thought necessary, and I accept it in a different jurisdiction, that really, in order to safeguard the interests of a suspect at the police station, there should be an appropriate adult.
Is there anything in Trinidad which is the equivalent of the code of practice under the Police and Criminal Evidence Act?
No, my lord. So far as I know, there is only the judge's rules.
And is there any document which sets out the function of the JP?
Again, not that I know, my lord.
And insofar as there was a confession here, was it retracted at any time?
Well, not in the voir dire.
At trial it was denied, wasn't it?
Yes, it was denied. And in the
But
voir
he
dire,
didn't give evidence.
no, but in the voir dire,
Voir dire.
Voir dire he did, yes.
yes, in the voir dire he did not. Yes, he did.
In the voir dire he said he'd never made it.
Yes,
He didn't say he'd made it, but it wasn't true. He said he'd never made it.
Yes, that's right. That's absolutely. Well, my lady, we have set out, because obviously it's the primary. If the confession goes, then there is no case, as it were. We have set out those grounds for finding that the confession either isn't inadmissible or ought to be excluded, both in the case and in our supplementary case. I could just perhaps indicate that there's a case of Aspinall at tab 150, a case where the absence of an appropriate adult was held to be fatal. But I appreciate that there are many issues that I have to cover, and I don't think I can improve on the way in which we have sought to set it out.
You'd need to say, presumably, for what I'll loosely call the Section 78 limb of this,
Yes.
in other words, the discretionary exclusion,
Yes.
that any judge who was asked to admit this evidence would have been bound to say, no, I'm not prepared to do it, it's unfair. It's got to be anybody,
Yes,
hasn't it? Yep.
Of course, that's the basis on which we put the point that the evidence was either inadmissible or should have been excluded. If I can turn...
Yes, sorry. The Court of Appeal, paragraph 64 of their judgment, electronic bundle 356, picked up this point about him not saying this confession was extracted from me, or I just was led by the nose, or I didn't really have any choice in the matter. He was quite clear that his case was a different one. And the Court of Appeal note that there's the passage where he gives his own evidence about the meeting with the JP. He told me that if I give him a statement, I tell him I'm not giving a statement, but then putting words into my own thinking and saying I wasn't in a fit state of mind to give a statement. I never say that. I just say I'm not giving a statement.
Yes, that was the earlier stage before he did.
Yeah, but that's his own evidence on the voir dire. It's not. I really didn't feel I had any option, or I was being led into this. I mean, his own evidence is not that type of case, is it?
Oh yes, I accept. Yes.
I mean, it's a pure question of fact whether he uttered the words,
Yes.
isn't it?
Yeah. Yes.
His case is that the JP is lying.
Yes.
So are the policemen.
Yes. Yes.
It's not that the policemen have over-encouraged him.
Yes.
It's that he steadfastly stuck to his decision not to say anything.
Yes.
And they falsely said that he had.
Yes. My lord, that's absolutely. Yes. So, My Lady, those are the submissions we make in relation to the confession. And if I can move to the issue of joint enterprise, we've summarised the points at part 3 from page 764 onwards. You have the point that the respondent admitted that there was a misdirection. And then, if we go on to the issue of whether there was a substantial injustice, the respondent relies on the passage at paragraph 100 of Jogi, which is in volume 2 at tab 30 and at page 742. And just looking at that at page 742, the board there says the effect of putting the law right is not to render invalid all convictions which were arrived at over many years by faithfully applying the law as laid down in Chanwing Hsu and in Powell and English. The error identified of equating foresight with intent to assist rather than treating the first as evidence of the second is important as a matter of legal principle, but it does not follow that it will have been important on the facts of the outcome of the trial or to the safety of the convictions. Well, we say that on this case it would be important because of the nature of the directions. Moreover, where a conviction has been arrived at by faithfully applying the law as it stood at the time, it can be set aside only by seeking exceptional leave to appeal to the Court of Appeal out of time. That court has power to grant such leave and may do so if substantial injustice be demonstrated, but it will not do so simply because the law applied has now been declared to have been mistaken. This principle has been consistently applied for many years. And then I won't take the board to the examples, but a number of examples have given. So the question where leave is sought out of time, which isn't really our position, although we are asking the board in the light of Jogi and Ruddock to permit us to argue an additional point here, is that if you, for instance, supposing that the matter had been disposed of by the decision of the board in 2008, and then Pitman were simply to come back in now and say, well, I want you to reopen it in the light of the decision in Jogi, it would be a different position than where the board has already seized of the case in the light of the issue of mental incompetence. And it goes a little bit further than that. Moreover, a case where the board, when it, as it were, last looked at it, sent it back to the Court of Appeal to say, look at the impact of the mental impairment which is asserted by Professor Kopelman and Jessica Bramham on a number of issues, including the issue of joint enterprise. So it was always contemplated that this matter would, as it were, go on. It wasn't a case where there was a decision in 2008 which finally disposed of this case, and then one seeking to reopen an otherwise final judgment. So we do say that those are very special circumstances in this case. Once it's as it were, through the door, that to leave what we say are, in the light of Jogi, really seriously erroneous directions uncorrected, once the board is seized of the matter, would be unjust. And so that's the point we make at 3.1 to 3.3. I hope that provides a ground for distinguishing this case from a situation where someone simply says after 10 years there was a misdirection. There it said you would have to demonstrate substantial injustice. But we do say that in any event there is substantial injustice here. And at 3.5 we say, firstly, there's the context of the misdirection. The sole evidence came from the confession statement, and the sole issue raised by the confession statement was whether the appellant had in any way assisted or encouraged the killing and done so intentionally. The appellant's statement strongly suggests he didn't, since he said twice, let us go, once before Agard went into the bathroom and once after Agard had been in the bathroom for a considerable period of time. And in those circumstances, we submit substantial injustice was caused by the judge's undue and legally erroneous emphasis on foresight of possible grievous bodily harm and whether it crossed his mind that Agard would use such violence. So that's the first point we make, the context. Then we say that it was serious and repeated, 3.7, and the passages are set out in the case at paragraphs 58 to 57. My lady and my lords, unless you wish me to take you to the individual passages, can I just summarise that it was repeatedly said by the judge if it crossed his mind. You have in the record the relevant passages at where is it? Passages in the judgment in the judge's summary of the supplementary record. Yes. There, I think you have the judge's summing up in. Yes, it's in the supplementary record, and the relevant passages are. What's it? Yes. Well, they're set out in our case, where the judge repeatedly says, if it crossed his mind. Page 480. Yes. Page 480 of the record. You see, members of the jury, your task is an important one because you have to interpret his statement if you find it was given and what would have been crossing his mind, what he understood to have been taking place around him. He carried them in the bathroom, he tied them up and stuffed them out. He knew if you accept, it's open to you to find this Confederate was known to these people, something crossing his mind. It's only evidence against him, mind you, remember that. And then later on, at page 480, line 25, said he tied this elder. If you accept his statement to have been given, what is crossing his mind, puts you around the rest of the bathroom. And then I told him, let us go. And he told me, he coming now. And he went with a knife in his hand to the bathroom. He coming now, and he's going to the bathroom with a knife in his hand, the maker of this statement. If you accept it, is accused number 2, knowing full well that there were people who are tied up with wire, gagged thing in their mouth, in a bathroom, people who he knows, if you accept his testimony, would have known because they were relatives of this other man with him. And you, having helped to tie up these people, having helped to hold them with this other man, you see this man walking to the bathroom and telling you he coming now, and you see him walking with a knife. Did it cross his mind that the person who was going in there, in that bathroom with this knife, might have gone there with the intention? So did it cross his mind that he might have gone there with the intention? And we say that the repeated reference to crossing his mind and the putting of the issue of would it have crossed his mind, and then over the page again, did it cross his mind that if he said these people were, and then it goes on, if it didn't cross his mind, these people would have recognised him.
Well, I think it's in the original general direction about the nature of joint enterprise, isn't it?
Yes.
It's certainly repeated time after time.
Yes,
right.
Yes. Obviously, the board had looked at this before under the pre-existing law and not found that there was a misdirection.
Quite.
But we do say that now that the confusion of foresight of possibility with intent has been identified and spelt out by the decision in Ruddock, one can see this as a repeated and serious misdirection, which is likely to have had a substantial effect on the outcome. And then the question of, can I invite you to strike out joint, but conditional intent, we deal with at 3.9. We accept that the passages, so at 3.9, we accept that in Jogi and Ruddock, the board found that conditional intent would be sufficient. But the submission of my learned friend is, well, conditional intent is enough. We say that overlooks the distinction, the importance of the distinction between intent and foresight that is at the heart of the Jogi decision. Can I just give the board again the references in the Jogi decision? So it's at volume 2, tab 30, and it's paragraphs 83 and 87, where the essential importance of there being intention is spelt out. Yes. And one sees also that at paragraph 889, where the board is laying down the importance of the new approach, the first is whether the defendant was in fact a participant, that is whether he assisted or encouraged. The second issue is likely to be whether the accessory intended to encourage or assist. If the crime requires a particular intent, D must intend to assist D1 to act with such intent. And then it gives the examples. And then at paragraph 92, in cases of secondary liability arising out of a prior joint criminal adventure, it will also often be necessary to draw the jury's attention to the fact that the intention to assist, and indeed the intention that the crime should be committed, may be conditional. So that's the conditional point. And so, my lady and my lords, those are the reasons why we say this was a serious and relevant misdirection given the clarification of the law in Jogi. And to my learned friend's argument, which we deal with at 3.10 and 3.11, that the jury must have found conditional intent, we say you simply can't say that it's a natural inference from the facts of the case that they must have found conditional intent. And equally, we say that the suggestion that they would have convicted anyway is one which one simply can't do by reconstructing from a direction which focuses on would it cross one's mind. I mean, it's a totally different issue. So
what is the test? It's not quite clear to me what the test is there. Assuming that there's a misdirection, as we can see there is, then the question is whether the proviso should be applied. Is that right? Or is it equivalent?
No, my lord, as I understand it, what Jogi is simply saying at paragraph 100 is we can't reopen all these cases.
No, I can't understand all that, but what is the test that has to be applied now?
Oh, yes. Well, my lord, yes.
Well, we can see the judge expressly said, now accused number 2 in relation to Pitman, the state need not prove that he intended.
Oh, yes. Oh, yes.
So they have a clear misdirection.
Oh, yes. In the classic case, which we say we are, a misdirection is fatal unless it can be said that the verdict would have been the same in any event.
Well, unless you could be sure that
sure.
it is.
Yeah, unless it's inevitably.
Is the test, do the authorities show that the test is that the court has to be sure that the verdict would have been the
inevitably been the same, yes. I would, yes, that's right.
I only ask that because there's quite a bit of difference of analysis in the respondent's case as to what the test is. Well, there are all sorts of tests.
Yes, I think what they're saying is.
So where is the clearest authority of the proposition that you have to be sure?
Well, they're set out in our case, but
just tell us one, and then I'll do later.
I'm sorry, my lord, there's so many. I'm not.
How many
Berry is a case, for example. I mean, but it's been repeatedly said.
I think they're set out in Lundy and Pora in this. The classic statement is by Lord Hope in the case that is cited in Pora.
That's right.
And Lundy.
Yeah.
Yes. If this is to be treated like a conventional appeal, then once there's a serious misdirection, the test is would you inevitably reach the same conclusion. Page 607, Beckford, their lordships cannot feel.
607 where?
607 of the electronic bundle. So it's paragraph 50 of our case. It's the inevitable test. there, my lord,
Yeah.
there then arises for consideration the question whether the jury would inevitably have convicted the appellant if the confession, clearly a powerful form of evidence against him, had not been omitted. The test is a high one. In Beckford, your Lordship's board stated in the circumstance of that case, their Lordships cannot feel with utter certainty that it is required in the case of capital murder the jury would necessarily have returned the same verdict. In Moses, the felony murder case, their Lordships cannot accept that on the evidence of the defendant's confession alone, where he said no more than that he had seen Pascal with a gun, considerable time before the incident, the jury must, if properly directed, inevitably have come to the same conclusion. So, my lord, that's the test. The only reason why I understand my learned friend, Mr. Knox, is going into diluted forms of the test, natural inference, is because he's saying, well, it's different once you're in a paragraph 100 of Jogi case, and that therefore, that there you don't approach it like you'd approach a conventional appeal where there's been a misdirection. But we say, for the very fact that this matter is properly before the board, it's a misdirection which the board we respectfully invite you to find should not ignore. And once that misdirection is there, the conventional test, there is a serious misdirection. Therefore, it's only if the jury would inevitably have convicted. And that's typically the case where there's, the evidence is just overwhelming that he must have assisted and encouraged, which we say, if you look at the bare facts of this case, the going into he's saying, let us go. The other person goes into the bathroom, despite him saying to him, let us go, goes into the bathroom. The jury had directed, if it crosses his mind, it's enough. If the jury had been directed, it's important to consider whether he intended that or he had a conditional intent that grievous bodily harm would be used all along. We don't accept that you could possibly say that they would inevitably have convicted. My lord, so that's how we respect. Thank you. So, as to the question, my learned friend, Mr. Knox's next argument, it's inevitable that there would have been a verdict of manslaughter in any event. And can I just get so the question of manslaughter is addressed in the Jogi case at paragraph 96, page 740. If a person is a party to a violent attack on another without an intent to assist in the causing of death or really serious bodily harm, but the violence escalates and results in death, he will not be guilty of murder but guilty of manslaughter. So also, if he participates by encouragement or assistance in any other unlawful act, which all sober and reasonable people would realise carried the risk of some harm to another and death in fact results. And then the test is objective. As the Court of Appeal held in Reed, if a person goes out with armed companions to cause harm to another, any reasonable person would recognise that there is not only a risk of harm, but a risk of violence escalating to the point at which serious harm or death may result. Now, and then the qualification is introduced at paragraph 97. The qualification to this, recognised in Wesley Smith, Anderson and Morris and Reed, is that it is possible for death to be caused by some overwhelming supervening act by the perpetrator, which nobody in the defendant's shoes could have contemplated might happen, and is of such a character as to relegate his acts to history. In that case, the defendant will bear no criminal responsibility for the death. So we make really 2 points there. Our first point is, if one looks at the position when the co-accused Agard on the appellant's account goes into the bathroom after the appellant has said, let us go, the harm that he does there is not a harm contemplated at all or intended at all by the appellant. That's to say that act is a separate act, which he doesn't assent to or encourage in any way. If, and it's clear he did, for example, consent to assist in and encourage the tying up, or, and supposing that the act of gagging had led to death, then that would be a classic case where one would say, well, you knew very well that he was going to gag the people, you were party to that. And the fact that it has an unforeseen consequence, you're still governed by the test is objective. Any reasonable person would recognise that there's not only a risk of violence escalating, so that the person thrusts it down the throat in a violent and fatal way, you would be guilty of manslaughter. But what we invite the board to do there is to focus on that incident where, after saying "let us go," he sees his co-accused going into the bathroom with, in fact, we now know, fatal intent. And we say that he doesn't assent to or encourage that harm in any way.
That's essentially, as it were, joint crime spent.
Yes.
New independent crime by the co-accused, isn't it?
My lord, that's what we respect.
Well, now, would that have been any different on the Chan Wing Soo direction?
Well, I suppose
you still had to show that your participation and foresight carried through to the fatal events, didn't you?
yes, and so
It's actually the same point, isn't it? As would have been over
as would have been.
trial.
Yes. Well, my lord, I could try and unearth the petition and see exactly how we put it last time. But no, I'm not trying to be. I'm just saying that it may be that the.
What I'm getting at is
Yes.
whether it can properly be said that the jury simply must have found that the robbery, that the killing in the bathroom was part of the robbery. Otherwise, they couldn't have convicted.
Yes. Yes.
That's what's troubling me.
Yes, I see. Yes. Well, that's the yes. Well, the jury just directed that it's enough if it crosses his mind, but that seems to go to that direction actually seems to go to. Then you remain jointly liable for his acts, and you have the necessary intent, both A and B, both the actus you're part of the actus reus, and you're part of.
All right.
You have the intent. Well,
Yeah.
Lady, my lords, that's the reason why we say it would be wrong to substitute manslaughter, and we also say that this case is brought within the terms of paragraph 97. And that this is something, in the language of a supervening event not contemplated, or at least there's been a break in the activity, and then there is some further action which is not contemplated. So that's the basis on which we say the verdict of manslaughter was not inevitable, and that manslaughter should not.
So what would have to be proved in order for a conviction of manslaughter to be sustainable?
It would have to be proved that he could be said to have assented to or encouraged when he went into that bathroom, he was intending to do some harm in any event.
Well, is that right, Mr. Fitzgerald? To convict Pitman of manslaughter, it would be sufficient, wouldn't it, to prove that he took part in a robbery, which is a violent act.
Yes.
Force.
Somehow, yes.
Quite. That it carried the risk objectively of some harm, and that what then happened was death in the course of that.
Yes.
You'd have to show a break.
Yes. Yes.
Absent the break, it's manslaughter.
Yes.
without argument, isn't it?
No. Well, I agree. On paragraph 96, your lordship put it. If he If a person goes out with armed companions to cause harm to another, any reasonable person would recognise that it might escalate. So
That is true, but it isn't. It isn't. I mean, that's the reason for it, but it isn't actually the test. But you have to demonstrate that they foresaw it. That's the whole point.
Yes.
If death is caused by an unlawful act to which I am party, I'm guilty of manslaughter, aren't I?
Yes. Well, my lord, yes. And so
So it's the causation point or nothing, is it? It's paragraph 97.
yes.
Is it in paragraph 97?
Oh, my lord, yes. That it is. It is that.
Is the chain of causation broken?
Broken, yes. Yes.
In order to decide whether it's broken, we apply the test in paragraph 97.
My lord, correct. Yes. I think, my lord, that is correct. So, my lord.
Sorry, just to look at what the appellant's confession statement said about this.
Yes.
We've got it in various places. We've got it in the summing up in the supplementary record at page 475 is the relevant bit, but it's quoted in various other places too. There, at line 16 onwards, we get the essential narrative. What he appears to describe is him and his co-accused going into the house. There are a man and a woman there. They seize them. Co-accused seizes the man. He seizes the woman.
475, Mr. Fitzgerald.
Oh yes, I'm sorry. I'm looking for 18. Yes, I'm obliged. Yes.
Sorry. They go into the house. There are two people there, a man and a woman. Agard seizes the man. He seizes the woman. The man tries to run. Agard pulls a knife. Agard carries him. Agard also takes the woman. So he, at this stage, if I understand it correctly, has handed over the woman to Agard, who has a knife, who is tying them up, taking them off to the bathroom and tying them up. Now, well, the question's a rather obvious one, whether that doesn't indicate a participation in a violent offence where he is handing over a woman to a man with a knife.
And that carry is your lordship putting to me that carries with it the risk, obviously, of some harm.
Well, one would have thought so.
Yes, and then thereafter that if something that it's
That's manslaughter.
yes. Well, my lord, really the point then is if there is a break in the activities that day where he says let us go, person says I'm going to go back. So the part where he has participated in it. If there's a break, then we would respectfully submit he hasn't consented to the infliction of any harm in that second incident.
Right.
Yes. So that's the basis on which we would respectfully submit that the substitution of manslaughter would be wrong.
Right.
But we have obviously addressed the situation if it is a case of manslaughter, and this is at 3.13, then we submit that on a conviction for manslaughter, the argument that the sentence would be the same or similar to, namely life imprisonment with a minimum of 40 years. We say that would be completely wrong in principle. We've set out the grounds. Firstly, the appellant's original wrongful conviction of murder led to the imposition of the death penalty and the actual reading of a warrant of execution. The current sentence of life with a minimum of 40 years was imposed by the Court of Appeal, and it was imposed on the basis that the death penalty was the correct starting point.
Just before you go on, could you just give us the reference to where the Court of Appeal said that? Could you just give us the page number of the Court of Appeals, of that part of the Court of Appeals?
You mean saying 40?
Yeah, the 40 years point.
Life of 40, yeah, yes, my lord, absolutely. It's at the very end of the Court of Appeals. Yeah, where is it? Yes, so it's the sentence is at page 358. And yes, it's at page 358 of the electronic bundle. And he's still a relatively young man, taking into account the comments of Dr. Maharaj. And while the likelihood of reform was not explored in any detail, yes, we are leaving open the possibility of release before the end of his life, but only after serving a minimum term of 40 years in prison. So that...
So the only reasoning, insofar as there is any reasoning, which there may not be, it's in paragraph 72, is it?
73, yes. Yeah, according to his sentence, it would
73.
be... Yes, it's just simply he deserved the death penalty, but there has been a constitutional breach in the delay. Therefore, we're going to substitute life imprisonment not to be released before the expiration of 40 years. Yes, my lord, there is no reasoning, but...
So it was a sentence for murder, if you
Yes, yes.
And
So
they don't address the question of what would be an appropriate sentence if it were a manslaughter case. They don't direct themselves as to on what basis it would be 40 years, and on that, therefore, on what basis it should be something smaller, as you would say, it would than 40 years if it's manslaughter. No. That simply hasn't been addressed at all.
No, because at that stage, the board had sent it back to them on the basis that there'd been no misdirection on
Thank you very much.
Yes. Yes. So, my lord, the stark issue is...
So you say, explains to Bagstaff that if it is a manslaughter case, then there's got to be a fresh sentencing exercise.
Yes.
Presumably conducted by the Court of Appeal.
Yes, my lord, we accept that the normal course would be for the board to send it back. But the only reason we have to grapple with this is my learned friend is saying there's no substantial injustice done because you get the same penalty anyway.
I follow that.
And we say...
Well, we'll grapple with that, but the Court of Appeal hasn't grappled with that.
No, my lord, they've given no indication of what, in the alternative situation where there was a conviction for manslaughter, would have been the appropriate penalty. We say, just as a matter of fundamental principle, it would have to be less. I mean, there are numerous cases where a penalty is substituted, and the court says, well, we've quashed the conviction for a far more serious offence. It's necessary to substitute a sentence which reflects our new finding, and it's here you couldn't get a more dramatic change than from murder justifying the death penalty to manslaughter, which doesn't justify the death penalty and leaves the sentence at large. I mean, we would respectfully submit that the appropriate penalty would be a long fixed-term sentence commensurate with the gravity of the crime. Bearing in mind that life means life, 40 years just means you won't even be considered until 40 years on this. And we would say that the appropriate substitution on conviction in manslaughter would not even be a life sentence, but might well be a long fixed-term sentence to reflect the obvious gravity of the underlying crime.
Would the sentencing judge have to sentence on the basis of the conclusions of fact which flow from the verdict of the jury?
Yes, my lord, yes. It's bound by the findings of the jury. But if the jury were misdirected, then you, as it were, ignore what they found on the misdirection. That's to say the murder.
Yes, but their conclusions of fact are there, admittedly relevant in their case to whether it was a murder case or not, but the factual conclusion the jury must have reached in order to reach that conclusion as a matter of law are still there. And would it be open to a judge to say, oh, well, we've looked at it again and we think the jury had that all wrong? They can't do that, can you?
Well, not only can they do it in our respect for submission, they'd have to do it if you're sentencing on the basis of manslaughter rather than murder, then the jury's finding that he was effectively encouraging and assisting the crime would go. And you just have to do it on the basis of paragraph 96 of Jogi, that he was party to a robbery where a reasonable person would foresee that it might get out of control and lead to something worse.
And that he did foresee it, insofar as... Because would that not be an aggravating factor?
Well, It crossed his mind. I see what you're saying. I'm so sorry, my lord.
I mean, I know that if you argue, you say cross his mind doesn't really amount to much.
Yeah.
I do take that point, but
yes.
I'm not saying that.
Yes, I see.
I'm not saying that we should do that.
No, I
on
see.
the contrary.
I understand. So what your lordship is saying is, well, at least the element of foresight that might happen was found. Well, my lord, my only problem with that is that where the jury has been misdirected, the question is how much one can give weight to what they must have found under the old direction. But, my lord, even if that were the case, it would be very different.
I have your point that it's still very different from simply saying 40 years, which is what you did get for murder.
Yeah. My lord, those are the submissions that we make in relation to the conviction appeal.
Well, now, I'm sorry, Mr. Fitzgerald,
No, sir.
before you leave it, you are going to have to deal with the felony murder point.
Right.
Now, I know you give us a short answer. You say because it was never left to the jury, we needn't even think about it. But the case made against you is that we have got to think about it. I can see that if in order for there to have been a conviction of murder on the basis of the felony murder rule, there would have to have been some jury decision which might have gone one way or another, then it might be difficult for this court to say anything about what it would have been. But I think what is said against you is there was no jury decision which would have had to be made if this was killing in the course of a violent robbery. That is, in law in Trinidad, murder.
Well, my lord, really my objection to it is just the first objection, which is that you can't be treated as guilty of something you haven't been convicted of. I mean,
no, what you're convicted of is murder.
Yes.
Perhaps there is a simple answer. I don't know. What decision, if this had been left to if felony murder had been before the jury, what decision was there for the jury to make?
you mean would they have had any?
Could they possibly have concluded anything other than that this was a killing in the course of robbery, which is enough?
My lord, can I reflect on whether I have any answer to that? But can I just make?
Did the judge give reasons for on the felony murder point?
I think he just told counsel that he didn't intend to direct on felony murder.
We don't have a transcript of that. All we have, but we do have, and it's not contested, the first affidavit of Mr. Sturge.
Yes.
Where he says, well, this was touched on from time to time, and the judge says he wasn't putting it.
Yes.
Now, we don't know, and we mustn't speculate why the judge didn't. There might have been a number of reasons. One may have been simply to avoid overcomplicating things to the jury.
Yes.
The other may have been that it has consequences on sentence, because if felony murder is left as a possible basis to the jury, there can't be a mandatory death sentence. Whereas if it's not left at all, there can be. But whether it was either of those or any other reason which led to the judge's decision, we can't know, and it's not relevant, is it?
Well, that's my respectful submission. But
that doesn't get you out of the difficulty that Lord Hughes has put to you.
No. Well, you mean, in other words, can this board substituted on the basis that there would be no alternative?
Because we've now, in the post-Jogi world, we've got to try and do justice.
Yes, I see.
Now, on the one hand, you're able to say, well, the ground has shifted. Look, it's now plain there was a misdirection.
Yes.
We then have to say, yes, but what is actually the consequence?
Yes, I see.
And if the consequence is that on his own confession statement, if true, if he was bound to be convicted of manslaughter, there can be no possible miscarriage in that. And if as a matter of Trinidad and Tobago law, that converted into murder, the question is what miscarriage of justice would there be in saying, well, that is the true consequence?
Well, my lord, can I answer the second one I'd make is a sentence imposed on the basis of a felony murder conviction would, we respectfully submit, on necessity have to be different.
And that's a separate point.
Yes, yes.
Is that established a matter of Trinidad law?
Because it's discretionary. Yes, it is, because it's a discretionary death penalty, so then it would be at large and you could get a fixed term sentence.
Yep.
And if the court does leave both to the jury, is it for the jury to decide which? I mean, presumably you could...
No, that's the trouble, isn't it?
That's the difficult- that's
There is
the-
no
yeah.
separate offence of felony murder. It's simply murder arrived at by a particular legal route.
And I don't believe...
And the decisions that Lord Toulson referred to, unless I've got them wrong, have the effect that if you can't tell from the jury's verdict which it is, the mandatory death penalty doesn't apply.
Absolutely.
Yes.
And I don't believe that it has been the practice in Trinidad and Tobago, but we'd be very interested to know if I'm wrong about this, for the judge to cross that bridge by putting a supplementary question and saying, members of the jury, I will ask you, in the event of returning a verdict guilty, to indicate the basis on which you have reached that finding.
Mr. Persado, who's present in court, I think agrees with your lordship.
Right.
That's the position.
Absolutely. So once felony murder has been left as a possible basis, then the court, for sentencing purposes, has to accept that that may have been the basis, and therefore a mandatory death sentence becomes unconstitutional.
Yes.
It's up to the judge to decide whether to leave both, is it? Or maybe you'd only leave the second.
No, it is up for the judge to decide.
Yes.
And the difficulty with interpreting the verdict is exactly the same as in a different context you get in England when there's a returned verdict of manslaughter, where, for example, both provocation and self-defence are an issue. There's no point in asking the jury, usually, because it may have been some of one and some of the other.
Yes.
But on either view, it's manslaughter in any event.
Yes.
And so the problem here is... which at least is troubling me, is why it helps you that it wasn't left to the jury.
You mean at this appellate stage?
Exactly.
Yes. Well, my lord, I'm very sorry, but I thought I had a simple answer. I
It was simple, Mr.
I realise on reflection I don't, and but I would still maintain this position that where and this goes to the issue of would it make any difference, where felony murder has not been left, obviously there's only one basis on which you can sentence, which is that it's murder based on malice.
Oh, well, then you've got a different sentencing question.
Yes,
I understand.
So the question of what verdict should be substituted, that's to say murder on the basis of felony murder, would be clear at the appellate stage, and that would have we say a very significant sentencing effect, and that I think there is authority from other jurisdictions that if you're only convicted on felony murder, it's different. And obviously the very fact that the legislature has now said that it's a discretionary life sentence if it's felony murder makes a difference. In other words,
leaving the...
Yes, I mean, in the US,
It's all very unsatisfactory, really.
Well, my lord, it were the board to substitute murder on the basis of felony murder, it would still make a massive difference, we respectfully submit, on the sentencing issue.
Well, it might or might not, but it's not for us, you'd say, I imagine. Is it now in the statute that where felony murder is in issue, the mandatory death penalty doesn't apply?
Yes, it is. Yes,
It may well be.
Well, it's constitutional. I think it's because it was abolished and reintroduced, and therefore is a law introduced after the Constitution.
Doubt if that works. Anyway, all right.
Yeah, well, it does because existing laws provisions.
Well, I appreciate that.
Yes, if it's not an exist. Yes.
Yeah.
Well, my lord, we will address the issue.
Yes, fair enough.
But we would submit that given that it is now the law that felony murder attracts a lesser penalty, that's to say a discretionary rather than a mandatory death penalty, it must be treated as a lesser degree of culpability, and that would have, in our respectful submission, to be reflected in a lesser penalty. Yeah. But my lord, if I can think of any further submission in relation to the felony murder point, can I add it in writing, perhaps overnight. But I'm conscious that there is a sentencing appeal which may require some time. Would it be convenient at this stage for me to move on to that?
It would, yes. Yes, you're already gone 20 minutes over your time estimate for the conviction appeal, but we understand that you've had to contend with quite a lot of opposition.
Maybe I should have foreseen them. So if I can take the board to the speaking note, because that really summarises all the points in the case and makes reference to the case and the supplementary case where necessary. And I hope will assist in short. So just to start with the appellants and their current position, both the appellants suffer from a medically recognised intellectual disability. Both have IQs of below 70. In the case of Lester Pitman, the board has the benefit of the Court of Appeal's express finding that he suffers from arrested or retarded development in the form of mental retardation. That's at paragraph 69E of the judgment and at page 358. In the case of Neil Hernandez, there was an express finding in the unchallenged psychological report of Dr. Gray that he suffered from a learning disability characterised by a full-scale IQ of 57. And learning disability, I understand, I know my lady will know, was the expression that was used instead of intellectual disability for a period, but it's the same concept. And the evidence of Dr. Gray was admitted by the Court of Appeal at paragraph 28. And the court recorded Dr. Gray's findings that Hernandez suffered from, I quote, a level of cognitive functioning that represents a learning disability at paragraph 24. So we are in the fortunate position of being able to address the board on the basis of some agreed facts. So both of them suffered from intellectual disability. Both of them had IQs below 70. In the case of Hernandez, it was very considerably below 57, and that was recorded in the Court of Appeal's judgment. In the case of Pitman, there was the range given of 54 or 67, but both were undoubtedly below 70, and the Court of Appeal characterised it as an abnormality of mind arising from arrested or retarded development. Neither of the appellants now face the death penalty, but Lester Pitman was read a death warrant and came within days of execution. Now, at the voir dire, some questions as to the level of mental functioning by reason of a childhood head injury were raised in the evidence of his aunt, and we've given the board the reference. But there was no inquiry into his psychological state before sentence was imposed, and no psychological or psychiatric report was provided to the judge or commissioned by him. And the board will have seen the fact that the lawyer representing him had considered a psychiatric report, but for various reasons did not pursue it. One of those reasons was funds. The other reason was he didn't think that if you were a secondary party, diminished responsibility applied. That is in stark contrast, the absence of any psychiatric or psychological report, to the position in those jurisdictions where the death penalty is discretionary. So that's the Eastern Caribbean, the Bahamas, Belize. In those jurisdictions, a psychiatric report is now mandatory in death penalty cases as a result of the decisions of this board and the Belize Supreme Court. In cases such as Petersburg, that was a decision of the board, and Mitcham, where the Eastern Caribbean Court of Appeal gave its own directions that in no case involving discretionary death penalty would there be.
How does it work in America, Mr. Fitzgerald? In those states where there is
it's always discretionary.
It's always discretionary.
Yes, but as a result of the case that's relied on, there's a whole series of cases that you can't have a mandatory death penalty.
No, I understand that. And is there therefore always, or is there in fact always a psychiatric assessment?
I can't say that for sure, okay. But we do have someone who knows about the US system here, and maybe I think the reality is, because there is a sentencing phase to which considerable resources are devoted, that it is very likely that in every case there would be...
I think it's quite likely. In lots of states, it's a jury question, isn't it?
Yes, and so the answer is that the quite considerable resources are devoted to the quite separate sentencing phase.
Yep.
You have legal aid, and they would have permission. So the lawyers would certainly be in a position to have a funded psychiatric and psychological report. I don't know of any case where there has not been one, but I can't say for sure that it always happens.
Thank you very much.
But in the case of Hernandez, the Court of Appeal, at paragraph 52, rejected the argument that the Trinidadian courts should adopt the approach of the US Supreme Court in Atkins. They rejected the submission that the judicial imposition of the death penalty on those suffering from mental retardation, in the words of the US Supreme Court, constituted a cruel and unusual punishment. And they held that the matter was to be determined by the legislature. So the result was that Mr. Hernandez's death penalty was set aside on grounds of delay only. Had it not been for that delay, the death penalty would have stood. And it would have stood despite the uncontradicted evidence before the court that he had a full-scale IQ of 57 and suffered from a learning disability. And so the decision of the Court of Appeal in Hernandez is significant. It may even have a significance beyond the sentencing stage and influence the way in which the prerogative of mercy is exercised, because they're basically saying a full scale of IQ of 57 is not a reason for not imposing the death penalty. It's not of itself a reason for not imposing the death penalty. And so we say it obviously has wide implications for later cases where there is uncontradicted evidence of mental retardation at the sentencing stage. And we've analysed the errors in the Court of Appeal's judgment in the case.
When was the last time that a death penalty was carried out?
Well, the Dole Shady 9 were all executed.
1999.
1999, yes. And there were two others executed after that. Briggs and... Was that in St Kitts? Yeah, Trinidad, yes. He was a domestic killer. Yeah, there was a domestic killer who was executed after the Dole Shady gang. I'm not trying to be... just there was 9 people who were executed together then. But, my lord, as we know, Pitman, none of the supposed safeguards worked in his case. He was, other than the safeguard of coming to the board, because he was read a death warrant after his matter had gone to the Court of Appeal and his matter had been considered by the Mercy Committee. And it just simply hadn't been picked up that this was someone with a disability. So, to the argument, well, if there is any problem, it will always be picked up by the prerogative stage. That's simply not the case, and it's demonstrably not the case, as we can see from Pitman.
I wasn't really advancing that. I was just interested to know what the position
No, sorry. But I just
yes.
While I'm at there, the principles of law relied on. We say, so this is really just a brief summary of the stages that we invite the board to make, and then I'll try to unpack them and develop them. So firstly, we say there's a long-established common law prohibition on the execution of persons who are of unsound mind, whether by reason of idiocy or lunacy. And I use the historical expressions without any disrespect to those so suffering. Those were the words used by Blackstone and by Chitty. And that prohibition is founded on the principle that such execution would constitute cruel and unusual punishment. Secondly, we submit that prohibition remained in force when the 1842 Offence Against the Person Ordinance was introduced in Trinidad, and when Section 4 of the 1925 Offences Against the Person Act came into effect. Section 4.1 of the 1925 Act provided every person convicted of murder shall suffer death, not shall be sentenced to death, but shall suffer death as a felon. Those words, we say, cannot be interpreted literally to mean that every person convicted of murder shall suffer death, because it was always recognised, even in 1842, that certain people convicted of murder, such as pregnant women and persons of unsound mind, could not be executed. because it can't be given a literal interpretation, we say only clear statutory words could have displaced the long-established common law prohibition on the execution of those of unsound mind and their concomitant rights.
But was that a prohibition of actually carrying out the death penalty, or was it a prohibition on imposing the death penalty?
Well, I mean, it was certainly a prohibition on actually carrying it out. There is some historical material which suggests that a judge presented with someone who was of unsound mind should grant a judicial reprieve so that the matter should be looked at.
Meaning what? That you don't pass or didn't pass sentence at all?
Well, no. There was a period of English law where you just recorded the sentence and you didn't pronounce it up until 1861, and then there was if you thought the person was of unsound mind, but the judge could grant what was called a judicial reprieve, where he thought the person was of unsound mind, so that then the matter could be looked at by the executive and a royal pardon granted.
But what actually happened in court at the end of the trial in the cases of the judicial reprieve? Did you have to pass the sentence and then say, but, given your state of mind, I'd gain to reprieve carrying out the sentence whilst the Home Secretary looks at it, or did you not pass it at all, or what?
Well, there were two. Can I just historically between the years 1836 and 1861, you could record the sentence but not pronounce it. Record but not you write it so you wouldn't pronounce it. But it had the same effect as. I mean, there was provision for you to record the sentence but not pronounce it.
So it didn't become public at all?
Well, yes, you just recorded.
It was written into the record.
It was written into the record, but not pronounced. You didn't say to the person, "I'm sentencing you. You'll be taken offence to the place of execution." After 1861, you had to pronounce it, but you could grant a judicial reprieve. And that judicial reprieve, so you would pronounce the sentence, then you would grant a judicial reprieve, and then the executive would come in.
Yeah.
But the Archbold continues to talk about the judicial reprieve even up to 1961 Archbold, after diminished has been introduced. We've put that in the supplementary case. So although we can't quote many cases other than in the 19th century where judicial reprieves were granted because other statutory procedures came in to affect the certification by a medical officer under the 1884 Lunacy Act, Lunacy Act, and then mental defective provisions. But interestingly, there's nothing in Trinidad in Section 4 of the Offence Against the Person Act which even says you have to pronounce it. It just says shall suffer death. And so we say Section 4.1 should always have been read as providing the convicted murderer shall suffer death, except in cases where the mental unsoundness of the defendant rendered execution cruel. The right not to be executed, so this is at 2.3, if one suffered from mental disorder of a degree that rendered execution cruel and unusual, was a legal right, based both on legal principle and invariable practice that was in existence at the time the Independence Constitution came into force. And it was therefore a preserved right of the kind envisaged by Lord Diplock in Maharaj. Perhaps I should at that stage take the board to that concept. It's at volume 5 and at tab 84. So this is in the case of Maharaj, the concept of the preserved right. If I can take the board to page 2132 of the electronic bundle, and there's the reference to page 2130. You can see the independence constitution set out at page 393. Hereby recognise and declare that they have existed and shall continue to exist the following human rights, And then subject to the provisions of 3, 4 and 5, no law shall abrogate, abridge or authorise the abrogation, abridgment or infringement of any of those rights, which would, and then they're set out. And then one has section 3, shall not apply in relation to any law that is in force. So that's the predecessor of our present section 6. And then section 6 is the equivalent of our present section 14, the remedy section. But Lord Diplock expounds the theory behind it at page 395 from C onwards. He cites from Lord Devlin on the Constitution of Jamaica. This chapter proceeds upon the presumption the fundamental rights which it covers are already secured to the people of Jamaica by existing law. The laws in force are not subjected to scrutiny in order to see whether or not they conform to the precise terms of the protective provisions. The objective of these provisions is to ensure no future enactment shall in any matter, which the chapter covers, derogate from the rights which, at coming into force, the individual enjoyed. And then that the same presumption underlies chapter 1 of the Constitution. It was stated by the Judicial Committee in De Freitas and Benny. In section 1, the human rights and fundamental freedoms which it is declared shall continue to exist are those which are expressly recognised by section 2 have existed. So to understand the legal nature of the various rights that are described in the succeeding paragraphs A to K, it is necessary to examine the extent to which, in his exercise and enjoyment of rights, the individual was entitled to protection or non-interference under the law as it existed. That is the extent of the protection of freedom from interference by the law. So we accept that one has to look at the pre-independence position to see in Trinidad to see whether the right, even if in a primordial form or based on settled practice, existed. That doesn't mean it's not capable of development. It means that something which you can identify as the right not to be executed if you're of unsound mind, existed, and it did. We respectfully submit that therefore that right not to be executed if you're of unsound mind is a pre-existing right preserved by the Constitution under a pre-existing law which section 6 says are protected. But once the existence of that right is recognised, this is at 2.4, it must be given effect under the 1962 Constitution and the 1976 Constitution. That is because section 5.2b of the 1976 Constitution prohibits both the imposition and the authorisation of the imposition of cruel and unusual punishment. So you can't say, I'll impose it because someone else is going to sort the problem out later. You can't authorise the imposition of a penalty which constitutes cruel and unusual punishment. And that's why we say you can't even sentence to death someone who is established before you suffers from mental disorder of a degree which makes it cruel and unusual punishment. So we say, a judge should never at the sentencing stage authorise a punishment which cannot lawfully be carried out because it is cruel and unusual. And the alternative point we make is this. The principle of the separation of powers requires that the common law prohibition and the concomitant constitutional right be given effect by the judiciary at the sentencing stage. It couldn't be constitutional for a judge to impose a sentence of death that could not lawfully be carried out. And moreover, it would be contrary to the principle of separation of powers recognised in CPSAD and countless other cases to leave the remedy to the executive. And can I just then take the board to volume 1, tab 14 for CPSAD, because this is a significant case in our discussion. In volume 1, at tab 14, page 387, can I just give the fact this was a case where before independence and afterwards until the CPSAD case was heard, you could be sentenced to detention during the state's pleasure. It had been during the governor's pleasure in the colonial times. The CPSAD case, following a series of cases such as Hines, Mollison and Brown,
held that you couldn't be sentenced to be detained during the state's pleasure, because that would violate the principle of the separation of powers. You had to be ordered to be detained during the court's pleasure. And that, although it may seem a small change, is actually a massive change, because it means that rather than it being an executive decision, how long you spend in custody if you're a child or a mentally sour patient, the judiciary have got to step in and determine both the sentence originally and provide for reviews. Now, none of that's provided for in existing law, but the remedy had to follow. So it's quite an extensive inroad into pre-existing laws based on the separation of powers. And my lady, my lords, if we look at paragraph 10, the wording of a sentence of detention during the state's pleasure indicates the progress and development of the detainee must be kept under continuous review throughout the sentence. And then the continuing review must extend to the duration of the detention as well as to the place where and the conditions under which the detainee is being kept, even if a minimum term for the detention has been set by the judiciary. The separation of powers is a basic principle on which the Constitution of Trinidad and Tobago is founded. Parliament cannot, consistently with that principle, transfer from the judiciary to an executive body which is not qualified to exercise judicial powers a discretion to determine the severity of the punishment to be inflicted upon offender. A system of public law already under which the people for whom the Constitution was provided were already living when it took effect must be assumed to have evolved in accordance with that. So must be assumed to have evolved in accordance with that principle. Before 1961, you would be sentenced to detention during the governor's pleasure. When the issue first arises in CPSAD, it said it's got to now be detention during the court's pleasure, and then relying not on Section 4 or Section 5 of the Constitution, but on the underlying principle of the separation of powers, which pervades the whole Constitution. And they're transforming existing law, pre-independence law, very considerably in reliance on the principle of the separation of powers. And if the board looks over at paragraph 13 on page 388, paragraph 13, the third sentence, as Lord Roger explained in paragraph 24, Sir Griffiths, counsel for the respondent accepted that a sentence the length of which fell to be determined by the executive violated the general constitutional principle of the separation of powers. To remedy that situation, the words of the statute were to be construed so that the determination of the length of sentence was placed in the hands of the court. Although the word construed was used, it is reasonably clear that what the board decided to do, albeit sotto voce, was to exercise the power to modify, similar to that under section 5.1 of the Constitution. And so, in other words, you can use the power to modify the existing laws to transform a power that was given to the executive into a power that's given to the judiciary. And we do say that that has parallels with our situation here. So that's the So we say at 2.5, as CPSAD establishes the principle of separation of powers as a basic principle on which the Constitution is founded, that principle can be invoked to justify the modification of existing laws where they confer on the executive a decision that is properly for the judiciary. And that principle would apply if the trial judge were otherwise obliged to pass sentence of death on a person who was plainly mentally disordered to the point that his execution would constitute a cruel and unusual punishment. Nothing in this argument seeks to invalidate the existence of the long-stop mercy provisions contained in the Constitution. Such provisions continue to play their role in the grant of mercy. But this is a quote from De Freitas and Benny: mercy begins only where legal rights end. And so if we then go on, the big problem in all these cases, as in the 5-4 decision in Matthew, has been the savings laws, which says you can't invalidate an existing law by reference to section 4 and 5 of the Constitution if the law existed at the time of independence. And because the board in Matthew, or the majority of the board in Matthew, found that the mandatory sentence of death was part of existing law. They found that you couldn't challenge it by reliance on section 4 or 5 of the Constitution. Therefore, can I take the board just very shortly to Matthew to show why it's of no relevance, or it's not a bar to the argument we make in this case. And
That's because you say there was a pre-existing law.
Yes, there was a pre-existing law. Moreover, in modifying the pre-existing law, we're not relying on 4 or 5 only, but also on the separation of powers. And there's nothing to stop that. My lady, my lords, can I just take you to page 284? And really, this is the ratio. Paragraph 14. So if you look at paragraph 13, it sets out section 6.
I'm sorry,
Page 284?
284.
284 of JB.
Yep.
So paragraph 13, the question in this case, however, is whether inconsistency with sections 4 and 5 has any effect on the validity of the mandatory death penalty. So the board had come to the conclusion that it would be a cruel and unusual punishment to impose the mandatory sentence of death. And it would have violated, therefore, section 5(2)(b) of the Constitution. And they say that at paragraph 12. It is a cruel and unusual punishment to impose the mandatory death penalty. But they then say, although it's cruel and unusual, is it saved by section 6? And at paragraph 13 they say the question in this case, however, is whether inconsistency with sections 4 and 5, which prohibit cruel and unusual punishments under 5(2)(b), has any effect on the validity of the mandatory death penalty. Section 6(1) contains an exception to the operation of the previous 2 sections. Nothing in sections 4 and 5 shall invalidate A, an existing law, B, an enactment which repeals and reenacts an existing law, etc. Paragraph 14 of the majority judgment goes, the Offences Against the Person Act was passed in 1925, replacing earlier similar legislation. It therefore cannot be invalidated by anything in sections 4 or 5. As the Constitution contains no other provisions which can affect its operation or validity, it follows that if one is concerned only to construe the Constitution as the supreme law of Trinidad and Tobago, there is no basis for challenge. And then they reject various suggested alternative routes. But that's the ratio. Now, if one asks oneself this question, is the argument that we are putting here one which seeks to invalidate section 4 properly interpreted? The answer is no. The appellants are not seeking to invalidate section 4 in its general prescription that convicted murderers shall suffer death. So it says generally they shall suffer. They are seeking to interpret section 4 as subject to an exception in the case of persons of unsound mind, which was always part of the common law. So interpreted, we say, section 4 should always have been read. Every person convicted of murder shall suffer death, except whether that would constitute cruel and unusual punishment by reason of that person's unsoundness of mind. That's been there right from the start, from Bracton right through Bracton, Hale, Cook, Blackstone, that if you're suffering from unsoundness of mind or you're an idiot, you shouldn't suffer death. And indeed, Blackstone goes so far as to say you shouldn't even be sentenced to death. But certainly the question of a judicial reprieve would always have to be considered. Now, for that reason, we respectfully submit that Matthew is no bar. And it's no bar, firstly, because we're not seeking to invalidate section 4, but to fulfill it, read with the exception which we say has to be read in. It could never have been given a literal interpretation, otherwise you'd be hauling off for execution pregnant women. And that was contrary.
But the pregnant woman example is a very good illustration of the distinction between imposing the penalty and carrying it out.
Well,
You could see why there would be a very good compelling reason not actually to execute a woman pregnant while she was pregnant. But that compelling reason would not go on forever.
Well, if the answer, no, well, my lady, but it shall suffer death. We submit it can't be literally construed, and it doesn't carry with it the implication, because it doesn't actually say it, that everybody, even if they're mentally unsound to the point of being an idiot or an insane person, must be sentenced to death. It just doesn't say that. So we say at 2.7, the ambit of the prohibition on execution and of the basic right not to be executed if one is suffering from any form of mental disorder which would render execution cruel and unusual, is something that is then capable of development. And such development is necessary to give effect to evolving standards of decency and advances in psychiatric understanding. And the relevant authorities are set out in the appellant's case. I won't take you through it, but perhaps we could just, if I could, invite the board to look at Reyes. That's volume 1, tab 12, at paragraph 26. So volume 1, tab 12, at paragraph 26, where can I just take the board to para 26 at E, that's at page 318. So the prohibition on cruel and unusual punishment is the prohibition in issue there. And Lord Bingham is saying at E, a generous and purposive interpretation is to be given to constitutional provisions protecting human rights. The court has no license to read its own predilections and moral values into the Constitution, but it is required to consider the substance of the fundamental right at issue and ensure contemporary protection of that right in the light of evolving standards of decency that mark the progress of a maturing society. And then it relies on Trop and Dulles, the US Supreme Court decision. In carrying out its task of constitutional interpretation, the court is not concerned to evaluate and give effect to public opinion for reasons given by President Chaskelson in the Macquaniana case. And then it sets out, if I can just take it from public opinion, maybe have some relevance to the inquiry, but in itself is no substitute for the duty vested in the courts to interpret the Constitution and uphold its provisions without fear or favour. And then it says that protection of rights, if public opinion were to be decisive, there would be no need for constitutional adjudication. Protection of rights could then be left to Parliament, which has a mandate from the public and is answerable to the public. But this would be a return to parliamentary sovereignty and a retreat from the new legal order established by the 1993 Constitution. By the same token, the issue of the constitutionality of capital punishment cannot be referred to a referendum in which a majority would prevail over the wishes of any minority. And so that's the imperative of constitutional adjudication. But we do submit that what Lord Bingham is saying is, even if it were the case that in the past it was only thought cruel and unusual if you were insane to the point of complete lack of understanding or an idiot to the point of complete lack of understanding, once it's recognised that there is a core principle that those who are unsound of mind should not be executed, that prohibition is capable of evolution.
Now, Mr. Fitzgerald, you formulate it, person of unsound mind should not be executed, but that does bring us back to the point raised by Lady Hale. Is this something more appropriately considered at the time of passing sentence or at the time of potential implementation? Now, you advance the argument, well, it ought to be addressed at the passing sentence stage because it's just as offensive to pass a sentence, which it would be inhuman to carry out, as it is to carry it out. But I wonder whether that's not oversimplifying things. It's well-established principle that a party facing a criminal trial has to put their cards on the table and run all their defences. It can't run one at trial and then when it's unsuccessful seek to appeal and run a different one. Now, that has particular relevance in the area in which we're concerned, because you'll know that it's not uncommon to have a defendant whose mental state might give rise to questions, but whose primary defence is, let us say, I didn't do it. And that the two can't be happily run together. Now, this is problems manifested in all sorts of ways. But if you've got somebody about whom the psychological and psychiatric evidence rather suggests they might have been the sort of person who do this kind of thing, but it's because of their state of mind, who they are, but it's not strong enough to amount to diminished, and their primary case is, it wasn't me, I was an innocent bystander, there's a real problem for defence counsel if they've got to put it at that stage. There is quite a serious case for saying that demonstrates why it's more apt for that side of things to be addressed post-conviction when all legal defences have been run and examined.
Can I try and answer that by
looking
at the position as we now have it in the Eastern Caribbean, Bahamas and Belize, where the death penalty is discretionary? That has to be confronted every time one gets to the sentencing stage. And you may have run at trial, I wasn't there, I didn't do it, but you still put before the judge, before he passes the death penalty, all the mitigation based on your psychological state, your background and all that, so that the judge doesn't impose the death penalty when he shouldn't impose it. So in a sense, the jurisdictions in the region have already crossed that bridge. And indeed, it's been crossed in America, where the death penalty is discretionary. And it is quite usual in every jurisdiction, save Trinidad and Barbados, for the person to say, I wasn't there at trial, or my confession should be excluded. Then the judge says, right, you're convicted now, we're moving to the discretionary sentencing phase. What have you got to say? Your lawyer says, well, actually, I think I ought to raise the fact that this person suffers from a psychological disability.
And in the states to which you've drawn attention, other than the USA, who decides those questions of fact, the jury or the judge?
The judge. So it's the judge who decides it.
Because in the USA, it's the jury.
Yeah, no, but that's the point. Lord Bingham was very clear in Ray's, because in fact the Court of Appeal of the Eastern Caribbean had held that the mandatory death penalty was unconstitutional, but said that the decision should be taken by a jury. And in Ray's, your Lordships and your Ladyship's Board decided that it should be taken by a judge. So just take a case like Ray's. Ray's, I mean, it happened some time, there was a big time interval, but in the Ray's case, he had run unsuccessfully diminished responsibility, came back before the Chief Justice to sentence him. More psychiatric evidence was put before the Chief Justice, and the Chief Justice said, effectively, I find that this person was suffering from severe depression at the time, and the death penalty is inappropriate. Take a case like Canonier, which presents your Lordship's point in more extreme form. We had just run before the Court of Appeal. Yeah. This person's confession should have been rejected, and he didn't get a fair trial on, I didn't do it. We then had to turn round at the sentencing phase before the same court on the same day and say, but in any event, he saw his father commit suicide when he was 7, and as a result he suffers from a long-standing personality disorder, so don't apply the death. It happens the whole time. Okay. So we respect...
I'm not suggesting you're wrong, but it's the way you see it mapping out this, that on conviction where there's a mandatory death penalty, the judge would be required to direct psychiatric or psychological reports, and the sentencing process would be deferred until that had been done.
Yes.
Then it comes back, and at that stage the judge has to determine what is a constitutional sentence in the light of the material before him.
My Lord, the only issue, which of course it's our case that it would be mandatory in every case, the only question is whether before you moved on to that phase there would have to be some material raised either by defence counsel, the defendant or someone, but we would submit that it should be a mandatory phase.
Yes, you could make good your submission without there being an absolute rule that there had to be a psychiatric report. You could make, you say at least, you could make good your submission on the basis that if there is sufficient reason raised at the mitigation stage to think that there's something to worry about, then you take it from there.
Yes, and the whole purpose, well, I know the board's very well, but just the whole purpose would be, if at that stage it's wrong to impose the death penalty because it foreseeably shouldn't be carried out. It's wrong in our respectful submission for the judge to do it, and it's inconsistent with separation of powers. And we do say that supersede is of some assistance.
The trouble is you're deriving this rule from a common law rule dating from the 19th century. Really?
Well,
aren't you?
Well, my Lord, Bracton is
13th
century.
All right, 13th century.
Okay, sorry, I see, sorry.
But that's the point at which the question which my lady raised becomes...
Yes, no, I'm sorry.
To me, at least.
I'm so sorry.
Not do you impose it, but do you carry it out?
Well,
Could we perhaps pause at that moment, it now being 1 o'clock, and no doubt you can come back with a perfectly formed sentence in reply to my lord. At 2 o'clock, you may even want to take us to some of the older materials that you have.
yes, my lady, we will.
Or not, as the case may be. The court is now adjourned.